All right, good afternoon, everyone, and welcome to our 7th Employer Lunch and Learn, where we share examples and resources aimed at helping our region's employers address workforce issues. My name is Kevin Kettleson. I'm a community development specialist with the Upper Minnesota Valley Regional Development Commission in Appleton. For those of you unfamiliar with our agency, we provide a variety of services, including planning, grant writing, community and economic development. We administer a revolving loan fund for small businesses, do regional marketing. We serve 5 counties in western Minnesota, including Big Stone, Chippewa, Lac qui Parle, Swift, and Yellow Medicine, as well as the cities, townships, school districts, and the Upper Sioux community. We've been doing these lunch and learns for about a year now. I think our first one was in March. And if you weren't able to attend the previous sessions, I'd invite you to check out our website. We have recordings as well as all the slide decks from our previous presenters listed there. I'll drop the link in the chat here to make it easy for you. And then as well, today's session will be recorded and the slides posted there too. So to go back and for you to go refer to them. And just a little background, this effort of doing the lunch and learns kind of stemmed from our, we had a regional workforce summit in Granite Falls back in November of 23, where the RDC and several of our regional partners planned and hosted an all-day event there, and we wanted to continue the effort of providing resources and examples to help you with your daily operations and recruiting and retaining workers. So that's kind of some background, and along those same lines, I just wanted to share with you that we are planning another workforce summit this spring for April 29th. We've partnered with the Southwest RDC out of Slayton and some of their partners as well to put on a big event. Like I said, the date was just kind of nailed down this week, so you guys are the first to know. We'll be sending out a save the date to everyone here shortly, but just wanted to share that with you. That'll be held at the Heritage Event Center in rural Taunton, so kind of between our two regions. Hope that the geographic center of the two regions is about as close as we could get. So again, watch for more information on that to come. And today I'll turn our focus to today's speaker. We have Alanna Galloway with the Department of Labor and Industry. She kind of randomly reached out to us in December, just looking for an opportunity to speak to groups. And I thought I have the perfect group for you, and talk to her about it. And this would be a good match. And by the looks of things, we had a lot of people sign up for today's session. So that's great to see as well. So Alanna will be giving an overview on all the new labor laws that went into effect here in 2025, especially the minimum wage, earned sick and safe time, pregnancy accommodations, misclassification rules, as well as the new law promoting salary transparency. Just wanted to let you know, if you have a question during the presentation, if you want to drop that in the chat, and then we can get to those at the end of the presentation, as well as any others that come up, after Alanna's presentation. So with that, I think I'll turn things over to Alanna to get started.
Thank you, Kevin. Good morning, everyone. How are you? I guess you're muted. But I appreciate the ability to speak to you today. As Kevin said, I did reach out because I'm an education and engagement specialist with the Minnesota Department of Labor and Industry and the Labor Standards Division. And so I'm here to speak to you today about earned sick and safe time and other Minnesota labor standards. I'm going to focus on earned sick and safe time because of how relevant it is to almost all workers, all employers in the state of Minnesota, as well as we are in the second year of its implementation, and there's carryover that can be confusing to some folks. So as Kevin said, my name is Alanna Galloway. I'm happy to, if you have any questions, please throw them in the chat or wait to the end, and I'll be happy to address them. So DLI enforces labor standards, including, but of course not limited to, the Minnesota Fair Labor Standards Act, Women's Economic Security Act, Child Labor Standards Act, Minnesota Prevailing Wage Act, Wage Theft Prevention Act, and other laws related to employment, wages, conditions, and hours. We do partner with other agencies in the state of Minnesota, including the Minnesota Department of Human Rights, Department of Employment and Economic Development, otherwise known as DEED, and other Minnesota agencies so that we can protect Minnesotans. So getting into Earn Sick and Safe Time, it was effective as of January 1st, 2024. It's paid leave employers must provide to employees in Minnesota. A worker is eligible for Earn Sick and Safe Time if they are anticipated to work at least 80 hours in a year for an employer in Minnesota and they are not an independent contractor in that work. There are some exceptions to who is covered in Minnesota's ESST law. Federal employees, volunteer and paid volunteer and paid on-call firefighters, volunteer ambulance attendants, and ambulance service personnel who serve in a paid on-call position, elected officials or a person appointed to fill a vacancy to elected office, an individual employed by a farmer, family farm, or family farm corporation to do physical labor or manage that farm if they are hired to work for 28 days or less each year. Building and construction industry employees who are represented by a building and construction trades labor organization if a valid waiver of these requirements is provided in a collective bargaining agreement, so union workers who waive this as part of their union contract, and certain family caregivers who have waived their rights to Earn Sick and Safe Time. For the vast majority of Minnesota employees, though, Earn Sick and Safe Time is applicable. And so what is this? What is Earn Sick and Safe Time? As I said earlier, it's paid time off from work that eligible Minnesota employees can use for certain reasons, including absence due to the employee or the employee's family members' mental or physical illness, treatment or preventative care, absence due to domestic violence, sexual assault or stalking of that employee or family member, closure of the employee's workplace due to weather or public emergency, or closure of a family member's school or care facility due to weather or public emergency. So it could be a snow day. We have lots of those in Minnesota. I know my kids' school closed on Tuesday because it was cold. And we all, of course, remember when COVID hit and lots of workplaces and lots of schools closed as a result. When determined by a health authority or healthcare professional that the employee or a family member is at risk of infecting others with a communicable disease, and as of 2025, we include bereavement leave, taking care of financial issues related to death of a family member or something, or a friend. So when we say family member, what does that mean? My little joke is that there are more people under the law that I'm able to take time off for than I'm actually willing to take time off for. And so the family members include the worker's child, their spouse, their sibling, their parent, their grandchild, their grandparent, they're a child of a sibling, so the niece or nephew of the employee, siblings of the parents of the employee, a child-in-law or sibling-in-law, and then any of the family members listed of an employee's spouse or registered domestic partner. So I could take time off if my husband's sister's husband is ill. I can take time off to care for him if I needed to do that. Any other individual related by blood or whose close association with the employees is the equivalent of a family relationship. And if someone's not covered by all of those things, and name up to one individually annually, one individual annually, in addition to those folks. And so family member is a very broad classification because the state understands that families look different. Many families operate in different ways. Of course, I said child, but for instance, that first bullet says child, including foster child, adult child, legal ward, child for whom the employee is legal guardian, or child to whom the employee stands or stood in loco parentis in place of a parent. And so even the word child is broad under this law. And so, like I said, the state of Minnesota does recognize that families look different and operate different. Many people are even living with many of the people on this list, as opposed to, just having responsibility to take care of their child, or just having the responsibility to take care of their spouse or their parent. Workers earn 1 hour of sick and safe time for every 30 hours worked. So that's 30 hours worked. That doesn't include paid time off, like a holiday or anything like that. That hours worked is time when the worker is working, and the time that they are being paid as workers. So an employee earns 1 hour of sick and safe time for every 30 hours worked, can earn up to at least 48 hours each year unless the employer agrees to a higher amount. So the law allows employers to cap that accrual at 48 hours. But of course, the employers have the right to be more generous than the law requires. And employers can cap that at a total of 80 hours, because employees can carry over that unused earned sick and safe time. And so I do have a little spreadsheet that I want to show you just as an example. This is an overview of an employee's accrual. This worker is scheduled to work 48 hours a week. And because it got too complicated, I didn't include any holidays or anything like that. And so this is 48 hours a week with no holidays. The first column shows the week count. The second column shows the number of earned sick and safe time hours carried over from 2024. The third is the number of hours worked per week. The fourth is the number of earned sick and safe time hours accrued in this current year, 2025. And the fifth column shows the total carried over from 2024 plus the accrual from 2025. This is a worker who's carried over all 48 hours from the previous year. At week 24 of 2025, they will hit the 80 hours for 2025 and stop accrual at that time, even though they have only accrued 48 hours and haven't hit the max 48 hours for the year. In week 28, they will take 20 hours off using earned sick and safe time. For this, they're taking Monday, Tuesday, and half of Wednesday. This, of course, reduces their 2024 hours to 28. So their total now is reduced to 60 hours. And because they no longer have the 80 hours total, they have not yet hit the 48 hours for 2025. The worker will begin accruing again ESST for the hours they worked for the second half of that week. Of course, they accrue fewer hours that week than others because they are working half the hours they do in other weeks. They'll continue to accrue that earned sick and safe time until week 40, when they hit 48 hours for the year of 2025. So even though they are not at 80 hours total, they will not accrue any more ESST until 2026. I'm hoping that makes sense. This spreadsheet makes sense. What I really want you to take away is that there's two caps here. There's the 48 hours that can be earned per year, and there's the 80 hours that can be total. So again, in week 28, I'm sorry, in week 24, this worker of 2025, this worker hit that 80-hour max. They hadn't yet hit the 48-hour max for the year 2025, and so but because they hit that 80-hour max, they stopped accruing. When they took more time, they continued accruing. When they took that time off, they restarted accrual until they hit the 48-hour max. So they can hit either the 48-hour max for the year or the 80-hour max for total. If they hit that 80-hour max and they have not yet hit the 48-hour max, once they use some time, they will continue accruing until they hit that 48-hour max. And so in week 41, or week 40 here rather, they're at 76 hours, they will stay at 76 hours until they get into the next year when they will start accruing again. Like I said, I'm hoping this makes sense. And so if I'll pause here in case anybody has any questions about how that accrual works. Okay. I'm taking that to mean that all made sense. There are some alternatives because that can get complicated. Those alternatives are front-loading those hours in lieu of ongoing accruals with carryover. The first option is front-loading 48 hours. A minimum of 48 hours of earned sick and safe time is provided to an employee and made available for immediate use at the start of each year. And unused earned sick and safe time hours are paid out at the end of the accrual year at the employee's hourly rate. And so if you would like to front load 48 hours, the unused time needs to be paid out. Another alternative is front loading 80 hours. So a minimum of 80 hours of earned sick and safe time is provided to an employee and made available for immediate use at the start of each year. And the earned sick and safe time the hours did not use are not paid out at the end of the accrual year. So the three options are accrual, as we talked about earlier, 48 hours front loaded with the payout at the end of the year, and 80 hours does not need to be paid out at the end of the year. The rate of pay is the employee's base rate. So employers must provide employees who use earned sick and safe time with pay equal to the base rate of the employee earns from employment. Employees must be paid at least the highest applicable minimum wage, of course. So whether you have a local minimum wage that is applicable in your area, that needs to be adhered to. The base rate does not include commissions, shift differentials, overtime, extra pay for working weekends or holidays or scheduled days off, bonuses, and tips or gratuities. So it's not as though they need to make what they would have made if they were working that day, but they need to make that base rate. So notice of use. If the absence is foreseeable, if you have a scheduled doctor's appointment or your child has a scheduled doctor's appointment, the employer can say you have to give 7 days notice for a foreseeable absence. If it's unforeseeable, right? If you wake up with a backache and you just can't go in today, of course, that's not something you can schedule as much as we would like to schedule our sick time. But that the employer can say to notify as soon as practicable. Employers cannot require reasonable documentation unless the employee has used earned sick and safe time for more than 3 consecutive scheduled days. That documentation can be a doctor's note. It can be a note from a volunteer from an organization that has something to do with that absence. So if it was, if your child has been out of school for 4 days because the school shut down for weather, right? On that 4th day, the employer can require a note, and on that 4th day, that can be a note from that organization, from the school, or from whatever organization. And that can be a self-authenticating note, right? It could be, I get migraines and I've been out for 3 days, for more than 3 days, 3 consecutive days. I don't need to go see a doctor. I know how to treat it. So an employee can write themselves and write a note that details what the issue has been and why to say that they've been out and that it is a eligible reason. Employers may not require that an employee find a replacement worker as a condition of using earned sick and safe time. Employers can't say, oh, you can use that as long as you find somebody to cover that shift. No, that is not the responsibility of the worker who is using earned sick and safe time. Employees can use earned sick and safe time in the same increments of time as they are paid, except that employers are not required to allow leave in increments smaller than 15 minutes. So for example, if an employee, would like to use 3 hours and 7 minutes of earned sick and safe time, the employer may require 3 hours and 15 minutes of earned sick and safe time be used. The employer, of course, or the employer cannot require employees to use more than 4 hours of earned sick and safe time at once. So by January 1st, 2024, or later or the date of hire if later, employers must provide the earned sick and safe time notice to employees in a manner that is at least as effective as one of these three following options: posting a copy of the notice at each location where employees perform work, providing a paper or electronic copy of the notice to all employees, um, or posting the notice on a web-based or app-based platform that employees use to perform work. The notice needs to be provided to employees in English and the primary language of the employee. The LI currently has sample earned sick and safe time notices available in 22 languages, and I think it's actually more than 22 at this point. And employers can request translation in additional languages as needed at no cost. Employers must keep accurate records of hours worked and earned sick and safe time taken. Employees have the right to inspect their records at a reasonable time and place, and records must be readily available for inspection by the commissioner upon demand and kept at a place of work or in a manner that allows compliance within 72 hours. At the end of each pay period, employers must provide employees with the total number of earned sick and safe time hours available for the employee to use, and the total number of earned sick and safe time hours that the employee used during that pay period. Uh, it used to be the case when ESST was first implemented at the beginning of last year, it was a requirement that it was listed on the paycheck stubs. The agency and heard from employers that said this is expensive, it's difficult, it's making things harder for us. And so that requirement has been removed. So that's no longer the case, but it does have to be available to the worker. Information can be provided through earning statements or electronic systems. If provided electronically, employees must have access to an employer-owned computer to review and print that information. And in addition, employers are required to keep records of hours worked as well as other information and must retain these records for 3 years. Retaliation is prohibited. So an employer may not discharge, discipline, penalize, interfere with, threaten, restrain, coerce, or otherwise retaliate or discriminate against a person because the person has exercised or attempted use of earned sick and safe time or made a complaint or filed an action related to enforcement of earned sick and safe time. It shall also be unlawful for an employer's absence control policy or attendance point system to count earned sick and safe time taken under this act as an absence that may lead to or result in retaliation or any other adverse action. Lastly, it shall be unlawful for an employer or any other person to report or threaten to report the actual or suspected citizenship of immigration status of a person or their family member to a federal, state, or local agency for exercising or attempting to exercise any right protected under Earned Sick and Safe Time Act. As of this year, an employer who provides employees with paid time off or other paid leave that is more than the amount required under the Earned Sick and Safe Time law for absences due to personal illness or injury, that additional PTO must meet the same requirements as the Earned Sick and Safe Time hours other than the ESST accrual requirements when used for an ESST qualifying purpose. So for example, if an employee receives 50 hours of PTO in addition to the minimum requirement of 48 ESST hours per year, the employer must follow the earned sick and safe time requirements about notice, documentation, anti-retaliation, replacement workers, and more for the additional PTO hours when they are used for an ESST qualifying purpose. So if somebody says, if they've used, um, if they're beyond that 48 hours, but they call in, they say, I have a headache, I can't come in today, that has to, the same rules have to apply. If they call in and they say, I have a flat tire, excuse me, the same rules don't have to apply because earned sick and safe time is not um, for something like a flat tire. So, just some other updates. Weather-related workplace closure exemption was created for emergency personnel, corrections faculty, staff, excuse me, and public employees with a commercial driver's license. Also, there was addition of remedies for earned sick and safe time violations. So employers may be liable for the amount of earned sick and safe time that should have been provided or could have been used, plus an equal amount as liquidated damages. And if the exact ESST hours owed is unclear, employers are liable for 48 hours for each year earned sick and safe time was not provided, plus an equal amount as liquidated damages. So for violations, employers can be held to twice the value of the earned sick and safe time that was not um, made available to workers. So I'm going to skip here, just some resources here. The ESST page is sickleave.mn.gov. If you have any questions, you can give us a call at 651-884-5075. We do have workers who take calls from 8 o'clock to 4:30 on a daily basis during the work week, and we have folks who respond to emails as well. So esst.dli@state.mn.us. You can also sign up for our wage and hour bulletin my colleague puts out every month. There's information about earned sick and safe time. There's information about all of the different labor standards that DLI enforces and that labor standards enforces as well. And so moving on to some of the other issues, like I said, I wanted to really do a deeper dive into earned sick and safe time because of its relevance and its prevalence, and because of the complexity of that carryover issue. So an employee notice is a notice that workers must receive from the employer at the time of hire. The employee notice, excuse me, must provide the employee's employment status and whether an employee is exempt from minimum wage, overtime, other state wage and hour laws, and on what basis. For information regarding who can be considered exempt, as well as information regarding other exemptions that may apply to minimum wage and overtime, you can check out our website. It also must include the number of days in the employee's pay period and the regularly scheduled payday, the date the employee will receive their first payment of wages earned, the employee's rate or rates of pay, and the basis thereof, including whether the employee is paid by the hour, shift, day, week, salary, piece, commission, or other method, and the specific application of any additional rates. It has to include the provision of paid vacation, sick time, or other paid time off, how the paid time off will accrue, and the terms for its use, a list of deductions that may be made from the employee's pay, the employer's legal name, an operating name if different, the physical address of the employer's main office, excuse me, or principal place of business, and a mailing address if different, and the employer's telephone number. These things can all be found on our website. This is the one in front of you is one that we have on our website. It is not required that that employers use the one that we have on our website, but it's a good sample and can be used. All employers must provide the notice to employees in English. The notice must include a statement in multiple languages that informs employees they may request the notice be provided to them in another language, and the employer must provide the notice in another language if requested by the employee. Earning statements or what we call pay stubs also are required the name that excuse me, it's required to include the name of the employee, total hours worked by the employee in that pay period, the total amount of gross pay earned by the employee in that pay period, as well as the net amount after deductions, a list of what those deductions would be, the date the pay period ended, the employer's legal and operating name, the earned sick and safe time. I'm sorry, and this is out of date now, of course, because as I said, sick and safe time does not have to be on the earning statements anymore. So that needs to be issued to the employee, excuse me, at the end of each pay period, either in writing or by electronic means that covers that pay period. An employer who chooses to provide an earning statement by electronic means must provide employee access to an employer-owned computer during an employee's regular working hours to review and print earning statements, and must make statements available for review or printing for a period of 3 years. An employer must provide earning statements to an employee in writing rather than by electronic means if the employer has received at least 24 hours from an employee that the employee would like to receive earning statements in written form. Once an employer has received that notice from an employee, the employer must comply with that request on an ongoing basis. Employers are required to keep records of earning statements for 3 years. Employers are already required to provide earning statements to employees. There was a provision that updated this, changed this to include that 3-year retention policy that went into effect August 1st of last year. A little bit more on record keeping. Employers must keep records including the employee's name, address, and occupation, rates of pay and amounts paid each pay period, employees' hours worked each day and each work week, certified payroll, specifically for prevailing wage projects, and other information. And this has to be available to the in the event that the commissioner finds it necessary to investigate, and that and other information has to be available to the commissioner within 72 hours. There's also a requirement to maintain hours worked each day and work week. Employees paid at piece rate, the number of pieces completed at each piece rate, a list of the personnel policies to the employee, including the date the policies were given to the employee and a brief description of the policies, and a copy of the employee notice, plus a copy of any written changes to the notice that were provided to each employee. What I didn't say is that about the employee notice, and I apologize, is that employee notice needs to be signed by the worker, and any changes to that notice have to be issued in writing to the employee prior to the change happening. Records must be kept available for inspection upon demand from the Department of Labor and Industry. Records must be either kept at the place where the employees are working or kept in a manner that allows the employer to comply with the demand within 72 hours. And if records maintained by the employer do not provide sufficient information to determine the exact amount of back wages due or earned sick and safe time due, DLI may make a determination of back wages due based on available evidence. Okay, so as of January 21st, 2025, minimum wage across the state has been at least, we'll say, more standardized. The small employer minimum wage, youth large employer minimum wage, and the J1 visa wage for hotels, motels, and lodging establishments have been eliminated. Employers are still able to use the 90-day training wage for employees under the age of 20, excuse me. And the cap on the annual adjustment of the minimum wage for inflation increased from 2.5% to 5%. Our minimum wage in the state of Minnesota is tied to inflation, but it was capped at 2.5%. But now it's capped at 5%. So the new minimum wage under the law, under Minnesota state law as of January 1st is $11.13 an hour for all employers in the state. There, as I said earlier, there's still the 90-day training wage for workers under the age of 20, and that's now $9.08. So I actually don't think I'm going to have time to get into really the Women's Economic Security Act, but the Women's Economic Security Act, real briefly, is an act that was based on things that people have found to impact women's economic security, of course. It includes wage disclosure, which basically means that workers have the right to talk to other workers about their wages. Nursing mothers and freedom to express milk on at work. Workers must have access to a separate and clean space to express milk. Pregnancy and parental leave. There's 12 weeks available for workers who have new children in the home. And that time, of course, that time is unpaid, but there is still in 2026, there's family paid leave coming, which will impact that, of course. DLI, not unfortunately, but DLI does not oversee family paid leave. That's under our Department of Employment and Economic Development. And then pregnancy accommodations are also overseen by DLI under WISA. I encourage you to take a look at our website in order to find more about the Women's Economic Security Act. So I'm going to skip. I'm sorry. I'm skipping this because I want to make sure we cover the things that I'm supposed to be covering here. There's a new, as of August 1st, 2024, the Drug and Alcohol Testing in the Workplace Act was updated to allow for oral fluid testing and pre-employment and employee drug testing. It includes alternative testing and retesting at no cost to the employee or applicant. That's effective, as I said, August 1st, 2024. That's not enforced by DLI as well. Sorry, I had some things out of order here. And then salary ranges are required in job postings. Employers with 30 employees or more must include a salary range estimate on their job posting. That also is effective January 1st, 2025, and is also not enforced by DLI. Restrictive employment covenants are void in service contracts. That's effective July 1st, 2024. The statute provides that no service provider may prohibit a customer from hiring an employee of a service provider, also known as non-compete clauses. That's effective July 1st, 2024, also not enforced by DLI. So if you have any questions, I appreciate so much
Wonder if she maybe left our meeting by accident, Taryn. Yes, she is.
I apologize. I intended to hit stop share and I hit leave instead. And so I apologize. Sorry about that. If anybody has any questions, I'd be happy to hear them now and try to answer them if possible.
Yeah, it looks like we have a couple of questions in the chat here. The first one, I think this goes back to your the part on, excuse me, the earn, stick, and save time. Question on the base rate. How do you figure the base rate for employees who may be receiving Davis-Bacon wages for a portion of the day and another rate for another portion of the day?
That I don't exactly know. Um, unfortunately. So I can speculate, but I will not right now,
Okay.
just
All
because
right.
I don't know the answer to that question.
Okay. And then another one here is they've seen paid on-call ambulance and fire was removed from the mandate. Does this include paid runtime, paid training, et cetera, or just the paid call time? They
So
pay wages when our volunteers are actually working.
so based on hours worked. So training time, call time, um, working time, that's all considered hours worked. And so I'm assuming this is about accrual. Um, and so hours worked, if it's under hours worked, and again, that's training time, on-call time, those are considered hours worked, and then they would be accruing based on those hours. I see that was a question from Scott. Scott, is that your question?
Can you hear me?
Yes,
Yep.
now.
So we pay all of our staff call time, but the ESST doesn't accrue with the call time, does it? Because you'd be working, 300, well, over 1,000 hours a quarter sometimes.
Right. And so I think that's why, and I don't have the specifics about that now so I think that's why that was, I'm just actually getting back to it in my presentation, and that's why I'm taking this long to answer. But I believe that's why the firefighters are removed from the statute. And I'm just getting back here, sorry. Because as you said, there it is. Paid on call, ambulance attendants and firefighters are not required to accrue based on they're not actually covered by earned sick and safe time. And I believe that's why.
Okay.
Because of how much on-call time there is.
Any other questions out there? Feel free to unmute yourself. I had a question. When we were referring to that employees did not have to, or they could write a note on behalf of themselves if they kind of have a recurring medical condition. Do they have to establish that medical condition? Have a doctor's note saying that this person does have repeating migraines, and if that comes up, it's covered, or can?
There's nothing in the statute that says that. So I don't believe so.
Okay, so it'd just be their word. Okay.
And again, there is a limit on the earned sick and safe time.
True.
And so it's not just free reign necessarily.
And that was for 3 consecutive days or more too, correct?
More than 3 consecutive days,
Yeah,
3 consecutive
3.
shifts.
Okay. Yeah. Okay.
So it would be into the 4th consecutive shift.
Mm-hmm.
When an employer can request some documentation.
Okay. Any other questions out there? If not, again, just want to thank Alanna for joining us today and sharing all that information. We will have, again, the recording of this session and the slides posted on our website in the next couple of days. I'll send out an email to those of you that registered with a link to that stuff, as well as a brief survey, just asking if this met your needs and if there's any other topics we could cover. looking ahead, I believe we were thinking about maybe holding another one in March. Stay tuned on that with us planning the Workforce Summit here end of April. Not sure if we'll have time to do that or not, but we do have some ideas out there for future employer lunch and learn. So just watch your email for any notice on future sessions. If we have any other questions, if not, I will sign off here. And again, thanks again for everyone for signing up and joining us today. Appreciate it, and stay warm out there. Thank you.